the next subsection of the rules. This subsection is conflicts of interest. It's important to note that conflicts of interest is the most highly tested subsection of all of these rules. Specifically, these rules will make up 12 to 18% of your total MPRE exam. The reason I'm pointing this out is because if you find yourself cramming at the last minute and preparing and trying to prioritize what you should memorize first or what you should be the most familiar with, this subsection of the rules is key. It is the most highly tested area of the rules on your exam. And just like the other sections, I won't touch upon every rule in the interest of time, but I am going to point out a handful of rules to you. The first rule that I would like to cover is all about current client conflicts. So here the rule says, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists in two scenarios. We'll take each up in turn. The first scenario in which you have a concurrent client conflict is if the representation of one client will be directly adverse to another. So for instance, you cannot represent plaintiff and defendant in the same matter simultaneously. They would have directly adverse interests. But there are some other less obvious examples that I would like to give you. If a lawyer is asked to represent the seller of a business, say in negotiations with the buyer who's currently represented by that lawyer, not in that same transaction, but in a different transaction, specifically an unrelated matter, the lawyer could not undertake this representation without the informed consent of each client. So while their interests are not directly adverse in the same exact matter, the lawyer is representing one party in one specific issue, and then a new party comes to them and asks to be represented by this lawyer against a current client in a different matter. That doesn't matter because you have client against client. That is a concurrent conflict of interest that needs to be consented to. Our second example says, but it's good to note that simultaneous representation in unrelated matter of clients whose interests are only economically adverse, such as the representation of competing economic enterprises in unrelated litigation, does not ordinarily constitute a conflict of interest and may not require the consent of both parties moving forward. So in other words, just because you might have parties that are competitors, generally speaking, or have adverse economic interests, doesn't automatically amount to a concurrent client conflict. The next scenario in which we have a concurrent client conflict is if there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, a third person, or by personal interests of the lawyer. So a few examples here to guide you. Let's say a lawyer was asked to represent several individuals seeking to form a joint venture. Is likely to be materially limited in the lawyer's ability to recommend or advocate all possible positions that each might take because of the lawyer's duty of loyalty to the others. The conflict in effect forecloses alternatives that would otherwise be available to the client. So if a whole group of people, say 2 or 3 people, come to a lawyer to be hired, to hire the lawyer to help in, say, starting up of a business, and the lawyer agrees to this type of joint representation, the lawyer owes a duty of loyalty to all of them jointly, and then is foreclosed or limited in his or her ability to help each of them individually, especially if those interests are, say, adverse or do not necessarily flow with the interests of the group in terms of the representation. Another example is when a lawyer has discussions concerning possible employment with the opponent of a lawyer's client or with a law firm representing the opponent. Such types of discussions could materially limit the lawyer's representation of the client. So this is a really good example of how the lawyer could be materially limited by their own interests. Say they're negotiating employment or interviewing for possible employment with the opposing party's law firm. This is obviously a problem. They're limited by their own self-interests. So let's say you're faced with a concurrent client conflict. How do you get around it? And in some certain circumstances, you can get around it and move forward. But in order to do that, the rule says, even if there is a current client conflict, the lawyer may represent a client if, 1, the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each of the affected clients. And 2, this representation is not prohibited by law. 3, the representation does not involve the assertion of a claim by one client against another client represented by this lawyer in the same litigation or other proceeding before a court. And finally, each affected client gives their informed consent confirmed in writing. So a few takeaways from this: you need all 4 of those requirements to be able to move forward with this type of conflict of interest. And more specifically, all of the affected clients must give their consent in writing. So you need to make sure that you have their signature after giving them informed consent and giving them all the information that they need to make an informed decision. However, some conflicts are not consentable, meaning you can never represent a plaintiff and a defendant in the same action simultaneously. And that's part of the requirements here. To give you a little bit more background, it's good to know that some states prohibit a lawyer from representing 2 defendants in a capital case. In such a case, this type of representation would be prohibited by law. So the lawyer cannot represent both defendants, even if the defendants would have otherwise agreed. So that's why one of your requirements here to move forward says that the representation cannot be prohibited by law. Additionally, let's say a lawyer represents a husband in a business matter where this lawyer learns and obtains confidential information regarding this man's finances. While the husband's business matter is still pending, wife then wants the lawyer to represent her in a divorce action. The lawyer cannot move forward and represent the wife. This would be considered an unconsentable conflict where the lawyer should not take on this representation even if the husband consents to it. The next rule that I would like to point out to you in this subsection is all about former client conflicts. So the rule says, a lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives their informed consent confirmed in writing. So just to stop there before I give you a few examples, it's important to memorize who has to give the informed consent confirmed in writing here, and it's the former client. So let's talk about some of these examples. It says a lawyer could not properly seek to rescind on behalf of a new client a contract drafted on behalf of a former client. That's a classic definition of the same matter. A lawyer cannot represent someone in drafting a contract and then down the road represent a new client trying to get out of said contract that they previously drafted. That would be considered the same matter for purposes of this rule. Additionally, a lawyer who prosecuted an accused person could not properly represent the accused in subsequent civil actions against the government concerning that same transaction. And again, I think this makes sense. You cannot represent, say, the government, say, as a prosecutor to criminally prosecute someone, and then later down the road represent that defendant in a civil suit against the government for, say, being prosecuted in that action. And then lastly, a lawyer who has represented multiple clients in a matter may not represent one of the clients against the others in a same or a substantially related matter after a dispute arose among the clients in the matter, unless all of the affected clients give their informed consent confirmed in writing. Also, it's good to note that this rule utilizes the phrase substantially related matter. I gave you a lot of examples about the same matter, but what does substantially related mean here in the context of this rule? And the rules define it as the same transaction or legal dispute, or if there is otherwise a substantial risk that confidential factual information that would normally have been obtained in the prior representation would materially advance the client's position in the subsequent matter. So, to give you an example, let's say a lawyer has represented a business person and learned extensive private financial information about that person. They may not then represent the person's spouse in seeking a divorce from them, because while those are 2 different actions or transactions, it doesn't matter. This lawyer has, confidential factual information about this person's finances that of course are very helpful and necessary in a divorce action against this person. So while those are technically not the same matters, they're substantially related enough to be encompassed by this rule. Another example, let's say a lawyer who has previously represented a client in securing environmental permits to build a shopping center would be precluded from representing neighbors seeking to oppose the rezoning of the property on the basis of environmental considerations. However, this lawyer would not be precluded on the grounds of substantial relationship from defending a tenant of this completed shopping center in resisting eviction for non-payment of rent. Because again, that's not the same matter and it is not substantially related to the initial representation regarding zoning and environmental concerns. The next rule that I want to talk about is similar to the former client conflict rule, but just in a slightly different vein. So it says a lawyer shall not knowingly represent a person in the same or a substantially related matter in which a firm with which the lawyer was formally associated had previously represented a client, if the interests are materially adverse to that person and about whom this lawyer has acquired information that was protected by the duty of confidentiality and is material to the matter, unless the affected former client gives their informed consent confirmed in writing. So what this is saying is if you're working at law firm A and you decide to take a job at law firm B, you can now not represent people at law firm B who have interests adverse to your previous clients at law firm A if you have confidential information about your previous clients that would be material to the matter. The only way you'd be able to move forward with that representation at law firm B is to get your former client's consent in writing, which they're probably not going to give you. But if they did, that would make this ethically permissible. It's also good to know that the rules and the comments to the rules make it clear that a lawyer who has general access to files of all the clients in a law firm and who regularly participates in discussions of their affairs should be inferred to be in privy to all information about the firm's clients. So in other words, just because you're not handling every single issue and every single case at your law firm, that does not mean that you aren't precluded if you switch firms from handling a different client file. In other words, if you're at a law firm and you can generally access all of the client files and you participate in discussions regarding client cases, we just assume you have confidential information about all of those clients. And of course, that would impact your ability to represent new clients at a new law firm under this rule. The next rule that I want to talk about is prospective client conflict. So first, let's define who is a prospective client. This is a person who consults with a lawyer about the possibility of forming a lawyer-client relationship with respect to a matter. We would call that type of person a prospective client. The rule goes on to say that even when no client relationship ensues, a lawyer who has learned information from a prospective client shall not use or reveal that information unless an exception to confidentiality applies. The rule then goes on to say a lawyer shall not represent a client with interests materially adverse to those of a prospective client in the same or a substantially related matter if the lawyer received this information from the prospective client that could be significantly harmful to that person in the matter, except as provided below. So to stop there real quick, this means if someone makes an appointment with you, let's say you offer free consults, you take the appointment, you meet with them, and you learn some basic information about their matter, but they do not end up hiring you. This means that you would be precluded from representing someone, say their adverse party, in the same or substantially related matter. We do not want lawyers gaining confidential information about client matters or prospective client matters and then using that information against those people later because a lawyer-client relationship did not exist. It's also good to remember that most of these conflict of interest rules that we're talking about are imputed to other members of your firm. And that's especially true here. So if you work at a law firm with 10 other lawyers and you take a prospective client meeting and they don't hire you, this means not only are you precluded from helping someone in the same or substantially related matter, but all of the other lawyers in your law firm are as well. And again, like I said, that is true for almost all of these rules. There are some exceptions, of course. One of those exceptions is if you have some sort of personal conflict of interest, maybe due to religious reasons or political reasons, those types of things are not imputed. But generally speaking, these rules treat all lawyers in a law firm as one person. So if one lawyer can't handle the matter, no one in that law firm can handle the matter. So how do we get around this prospective client conflict issue? Because no lawyers would ever want to take a prospective client meeting because obviously this would impede and impact their ability to take on new business. So the rule goes on to say when a lawyer has received disqualifying information, representation would be permissible in two scenarios. Situation number one is if you receive that informed consent from both clients. So this means all of the affected clients, meaning the affected client and the prospective client, has given their informed consent confirmed in writing. That's option number one. Or option number two is screening. Screening here requires that the lawyer who received this disqualifying information took reasonable measures to avoid exposure to more disqualifying information than was reasonably necessary to determine whether or not to represent this prospective client. And 2, the disqualified lawyer is timely screened from any participation in this matter and is apportioned no part of a fee from that matter. And finally, written notice is promptly given to this prospective client. So screening is obviously common. It's something that you will encounter throughout your review of these rules. But the idea here is that this lawyer who sat in on this prospective client meeting took care to not receive too much information. Basically just got the basics. Then from there, we screen this lawyer off the matter. We make sure that they're not able to participate or they do not get paid on the matter, and we give notice to that effective prospective client about the situation and about the screening that's in place. The next rule under this subsection of rules that I would like to discuss is shifting gears just a little bit, but nonetheless a conflict of interest. So the rule says that prior to the conclusion of the representation of a client, a lawyer shall not make or negotiate an agreement giving the lawyer literary or media rights to a portrayal or an account based in substantial part on information relating to the representation. And it seems like a rather basic rule, but I just want to stop and kind of break this down a little bit. This means if you encounter a scenario where maybe a client is running out of funds or running out of money and they can't pay you as the lawyer or the lawyer in the fact pattern, the lawyer cannot gain an interest in literary or media rights in the client's case while the matter is ongoing. They cannot even negotiate this type of agreement. So they can't even negotiate it for it to take effect thereafter. It is completely off the table for discussion while the matter is ongoing. And I think it's helpful sometimes to think about the rationale for why these rules exist. And I believe the reason for this rule's existence is we do not want lawyers to be at all motivated to handle a client matter differently because it might make a good movie or a good book or a good television series. We want to make sure that the lawyer is not motivated in any other way other than simply wanting the best thing for the client based on their skill and judgment. The next rule under this subsection that I want to talk about is very specific. It's all about a lawyer's ability to potentially waive malpractice liability. So the rule here says that a lawyer shall not make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making this agreement. So just to stop there, this is the only place in all of the rules where your client has to be independently represented by a different lawyer in entering into this agreement. You will notice upon your review of these other rules that there are plenty of other places where the rules tell you to encourage your client to consult with an independent lawyer prior to entering into, say, a business transaction with you. But ultimately, if your client decides against hiring independent counsel, they can move forward with the agreement without being independently represented. However, here, when it comes to waiving prospective malpractice liability, your client has to be independently represented to enter into this agreement. There is no exceptions. So if your client is not independently represented, they cannot ethically, and you cannot ethically, enter into this agreement with them. The next part of this rule says that a lawyer shall not settle a claim or a potential claim for such malpractice liability with an unrepresented client or a former client unless that person is advised in writing of the desirability of seeking advice of independent counsel and is given a reasonable opportunity to seek advice of that independent legal counsel in connection therein. So this is a classic example where the rule is encouraging you and telling you that you have to encourage your client or potential client or former client about the desirability of getting outside counsel before they make a decision on that agreement. But at the end of the day, if they opt out or do not want advice or representation from independent counsel, that's ultimately their decision, and you can move forward in the settling of a claim with one of these people. So again, I just like to make that point very clear. The next rule that we're going to discuss is all about conflicts of interest still, and it's speaking to the situation where someone works as a government attorney and then transitions into the private sector for work. So here the conflict of interest rule says, except as the law may otherwise expressly permit, a lawyer who has formerly served as a public officer or employee of the government is subject to former client conflict rules. So stopping there, that's the rule that we've already covered about former client conflicts. Additionally, these people may not otherwise represent a client in connection with a matter in which the lawyer participated personally and substantially as that public officer or employee, unless the appropriate government agency gives their informed informed consent confirmed in writing to this representation. So let's stop there. We have some new vocab or phrases that are being utilized in this rule. Specifically, it says that if you had worked on a case personally and substantially while in government practice, you can't then participate thereafter in the private sector. The only way you can move forward with that is if you get the government agency, in other words, your former employees, informed consent confirmed in writing. So when we see these words, we kind of have to define them in the context of this rule so that we can apply them properly to fact patterns. So this rule utilizes the word matter. Here, matter is narrow, and it means a specific set of facts involving specific parties. So to give you a quick example, let's say a lawyer who worked on regulations for an agency when she worked for the government, and then she moved into private practice, and she was asked to argue that the regulations were not being applied properly to a specific party. This lawyer can represent that party and can make that argument because drafting regulations is not considered a matter since it does not involve specific facts or specific parties. Additionally, the rule utilizes the phrase personally and substantially. So what does that mean so that you can work on applying this properly? Personally and substantially means that the lawyer was in fact personally involved in the matter previously. So to give you some examples, lawyer, let's say, is a senior attorney in the county. And this lawyer's responsibility is to rubber stamp her signature on every single case that comes through the county. This lawyer is not considered to be personally and substantially involved in every single case in which she rubber stamped. She would only be involved in those ones in which she truly participated in. It's also good to note imputed disqualification applies here too. So the rule tells us that when a lawyer is disqualified from representation under this rule, no lawyer in a firm with which the lawyer is associated may knowingly undertake or continue to represent in such a matter a party, unless the disqualified lawyer is timely screened from participation in the matter and is apportioned no fee from that matter, and written notice is promptly given to the appropriate government agency to enable it to ascertain compliance with these rules. So much like we've seen throughout many of these other rules, here if you would be disqualified from participation in a matter because you participated in it personally and substantially as a government lawyer, once you're in private practice, if you can't participate in a matter, no one in your firm can unless they take steps to screen you off of it. And then the last rule that I want to cover today is essentially the reverse or flip-flop of that last rule that we just covered. So this rule talks about a lawyer going from private practice and transitioning into governmental work. So here the rule says, except as a law may otherwise expressly permit, a lawyer currently serving as a public officer or an employee is subject to the present client conflict rules, which we already covered, and the former client conflict rules, which again we already covered. Additionally, they may not participate in a matter in which they participated personally and substantially while they were in private practice or non-governmental work, unless the appropriate government agency gives their informed consent confirmed in writing. So just to stop there, you see that they utilize that phrase personally and substantially again, which we already defined in the previous rule. And the other thing I'd like to point out that no matter which rule you're looking at, and by that I mean if you're a lawyer that's going from government practice into private or from private practice into governmental work, no matter what, the government will give you their informed consent confirmed in writing if you're looking to avoid a conflict of interest. So that's kind of an easy way to remember this. Under either rule, the government will have to give their informed consent confirmed in writing to your ability to work on a certain case if there is a conflict of interest here. So let's say a lawyer did zoning ordinance work in private practice for a company where he challenged zoning ordinances. The lawyer then leaves private practice to work in the public sector for the government, where he rewrites the zoning ordinances that he used to previously challenge. While working for the government, the lawyer would need informed consent in writing from the governmental agency where he was working due to the nature of his previous work in the private sector. The next prong of this rule says a lawyer may not negotiate for private employment with any person who's involved as a party or as a lawyer for a party in a matter in which the lawyer is participating personally and substantially. And again, I think this makes sense if you reflect back on the current client conflict rule. We do not want you to be materially limited in the representation of a client by your own self-interests. And here I almost feel like this rule echoes that sentiment. You shouldn't be negotiating for employment if it is going to be causing some sort of conflict conflict of interest in the work that you are currently doing. There is an exception to that. The one exception that's carved out here is for law clerks. So if you're a law clerk to some sort of judge or adjudicative officer or an arbitrator, you are allowed to negotiate for private employment. I think the reason for that is because those jobs are considered rather temporary, and we know that people move on from them. And obviously negotiating for employment is a necessary piece in being able to move on. So that wraps up all the rules that I wanted to cover under the conflict of interest subsection.